Hello and welcome to Dialogue. I'm Yang Rui in Beijing. China's highest court made a bold decision in 2011 to publicize judgment documents through a national online database. The decision has ignited a debate about the possibility of greater judicial transparency in the country ever since. In the 3 years that have passed, the online database has publicized more than 20 million judgment documents, and the website has been visited more than 2 billion times. So how do the publicized judgments affect the judicial system, lawyers and citizens? What kind of role does it play in the judicial reform of China? What's the boundary between judicial transparency and privacy? To discuss all these issues and more today, I'm very happy to be joined by Zhang Yongjiang, Chief Judge of the 4th Civil Division of the Supreme People's Court, and also Anna Tangen, author and columnist. But before we get started, let's take a look at this.
China's Supreme People's Court has released the revised stipulation on disclosing judgments and verdicts online. The court says it will provide easier access as well as proper protection for privacy. In July 2013, the stipulation had run a pilot on a new website named China Judgments Online. Up till now, the website has become the largest of its kind in the world, with more than 20 million Chinese judgments on it. Its total visits have reached over 2 billion, with a quarter of those from overseas. Services in multiple minority languages are also offered. After 3 years' practice and much deliberation, the revised contents have come out. It stipulates all judgment documents should be made public, except for those involving privacy and classified information. Besides the contents revision, the Supreme People's Court has provided easier access to the online judgments and verdicts, and the users can click into the app for service anytime, anywhere. The revised stipulation will be effective from October the 1st, and the online service will face more detailed guidance.
Now, gentlemen, first of all, Judge Zhang, what's the background against which the release of such judgment documents online has been made possible?
So actually it's part of judicial reforms, and our judicial reforms has been taking place for quite some time, and now we are involved in the so-called four round of reforms, and one of the most important parts is to make our judicial systems to be more transparent and more open to the public.
Are you prepared for the oversight?
Yeah, so I'd say the initiative of this publication of judgments were first put forward by Zhou Qiang 3 years ago, and through all this time, almost all the judges and courts are well prepared for this, I suppose.
Are you surprised about this bold decision, Anna?
Oh, not at all. It's a win-win situation, because what you have, by publishing these cases, you're providing guidance to younger judges on how to decide cases. You're instilling a lot more confidence in people because they get to see the application of the facts and the conclusions of law that go into these judgments. And absent sensitive materials like divorce and custody and things like that, and political issues, this is very, very much in line with making a very much more modern judicial system for China.
Do we have a lot more to learn from Europe and the United States? For example, are we going to transform our legal system into a common law system or a case law system like in the United States?
So actually, traditionally speaking, we have generally two systems, or two legal systems, that is case law system and civil law system. And China is regarded, or regarded most of the people, as civil law system. And now globally speaking, there is a trend for the convergence of laws between these two systems, and by such kind of publication of judgments, we are trying to make our young judges to be more confident about the judgments, but anyhow, it's quite different from those precedents of case law systems, and these cases or these judgments can be taken only for reference, not for presidents.
There's no doubt that this bold decision by the highest people's court aims to cultivate a spirit of professionalism. And do you imagine that the younger generation of Chinese judges would come under tremendous pressure to behave properly in front of the media scrutiny?
Well, I don't think there's any evidence that they're behaving improperly. It's not the younger judges. There was a period in time when there were questions about judgments that were being held in secret, when basically no one really understood what facts were being judged, what conclusions on the facts, and then how the law was being applied. This actually is a tremendous benefit to these young judges, as you pointed out. Now, this is not only just for China. China is embarking on a regional economic basis with the Silk Road, G20, all of these things. And when you start looking at that, this idea of convergence, of being able to set legal precedents on a very professional level that can be spread out regionally. Because imagine 29 different countries, over 50 different countries will be involved eventually in this Silk Road thing. You need to have a very professional, very standard system to address all the kind of things that are going to come up as part of that.
Judge Zhang, 3 years have passed since the decision was made by the court authorities in Beijing to promote transparency. Are you surprised that the visits of such publicized judgments and verdicts, of course, are tremendous, millions of them?
Billions, 2 billion.
Yeah, 2 billion. And many
it's
come
shocking
actually,
numbers,
shocking number. Many come from the United States.
Mm-hmm. Yeah, so actually you see what is going on in China and what is going on in China courts and what is going on in the China markets, all such kind of things could be seen through the judgments by China courts. And it is very easy for them to get access to all these, such a tremendous number of judgments. Of course, they will pay attention to such a they call golden mines, and to take information from such a website, of course.
But this is exactly what we're talking about in terms of convergence. The U.S. lawyers who are looking at this on behalf of their multinational clients are trying to instruct their clients on what they can and cannot do. And that's going to be based on how do cases turn out when people do these things. This is where the law is not about opening it up and saying, oh, anything can happen if you file a lawsuit. It's actually for judicial economy to make sure that you use your courts wisely, because it's a resource. You have to make sure that it's very predictable, that you know the outcome prior to getting into a situation which is going to cause trouble. And this is what people are looking for.
So you see a lot of foreigners or foreign business, they wish to come to China to do business, and they try to know what are your rules and how these rules are applied, whether the outcomes of judgment could be anticipated. All such kind of things are great concerns of those businesses outside China.
And in the past, especially during the early parts of WTO, China had a poor reputation, mostly because there was a lot of unfamiliarity, but also because China was not invested. In IPR, for example, China came into a system where they had no real ownership, but now China is the leading application file, patent and trademark filing in the world. So now there is this desire to maintain these types of systems, and you have to have the rules and regulations that go along with it.
Mm-hmm. Despite the astronomical figure of 2 billion visits so far, authorities of the highest people's court still express their dissatisfaction with the current level of the visits. Why? We are already surprised by the shocking number.
So actually, compared with the amounts of cases we are dealing with, you see, it's still amount of the judgments. Of course, the just from the figures of these judgments publicated in this website, it's a huge amount. But compared with the case we are dealing day by day, it's not a big amount, actually.
Tuesday morning, a press conference took place in Beijing to live up to the expectations of many who are very curious as to what will be answered, what questions will be raised by the media in Beijing. So, are you impressed by some of the questions? What are the most interesting questions you have ever had this morning?
So actually, some of the great concerns is about the protection of privacy, and actually, when we make the new regulations, we try to make a very good balance between the values of transparency of judiciary and the protection of privacies. And there are some clauses or speculations about which kind of information should be deleted before the judgments are put up, and which should keep away from the internet, from the
publication.
But I'm afraid the decision about what kind of information should be posted online is actually subject to the whims of the judges and authorities of the courts at different levels. In fact, people are asking, what will be the standards for the interpretations by judges as to what should be posted and what should not be?
So actually, we have got a principle, so-called all-around opening. That means it is a rule to publicate all the judgments, all the rulings, with the exceptions detailed and prescribed. And if you do have some parts or some judgments kept away from the line, and you should publicate a notice or some explanations why you don't put such kind of rulings to the internet.
And this sounds very subtle, but it's very, very important. Because when you put the onus on the judge to say, look, you have to publish, or you have to state why you are not publishing it, all right? And this is going on the record. So if you see a judge consistently not willing to publish, this is not going to only draw scrutiny from the public, but it's going to draw scrutiny from lawyers and other
However, gentlemen, should a serious dispute take place between the courts and the visitors of the website documents, online documents, who will exercise the final judgment?
So actually, up to now, I haven't seen any dispute about such kind of publications between a court or the client. Yeah. Anyhow, if a person of a party bring up a case, bring up a dispute to the court, he will be informed that, please be prepared. The outcome of the judgment will be put up to the internet when you agree. Yeah. If you not agree to this, and you should give reasons. And so actually, it's a pre-agreement between the client and the court for the publication of the judgments.
As someone who has lived in China for a number of years, are you prepared to witness evolution of the legal reform in China? Because obviously, judges, young and old alike, in the legal system in China will go through a period of pains, and they will be called unprepared by the very severe scrutiny of the general public and the media in particular.
Well, I think you're looking at this in the wrong way. I think this is much more of an aid to these young judges. I mean, they don't know, all right? They're very, very much afraid of making the wrong decision. It's not that they're trying to do something very weird or come up with their own ideas. They really want to follow the law. They want to follow the general idea of these rulings. So this idea, it actually prevents media scrutiny, because in the absence of a publication, that's when you start to have problems. People suspect that there's something going on. Once you can get rid of that, this takes an enormous amount of pressure off these young judges in particular, because they now don't have to explain it. It's right there. You can see it. If you have any questions, you can go to the website and you can look at what the ruling is.
Here is a closer look at the rule of law that is taking root and taking shape, not only in China but other developing countries, so to speak. Let's look at the issue of corruption. The independence of the judicial system always captures media attention. particularly in China, which is allegedly put under the leadership of the Communist Party, and therefore many in the West would say, hey, you won't be able to enjoy independence. So the oversight of exercising judicial independence would be crucially important for those who want to make serious investment here, who want to protect IPR, for example. So what can you tell us about the release of such judgment documents on the internet to avoid and minimize intervention from the administrative departments at different levels, and of course to regulate, if not limit, discretion of the judges?
So actually you see the parties of a case, especially those losing parties, they tend to be in the recent or some years ago, they tend to be suspicious about the behavior, the act of the judges, and they always have some doubts or some suspicions about whether something on the table or something dark. And if they lose, they say, okay, something has been done with the judges.
Yeah. It wasn't my case. It was something else.
It's not because my case is something other than the case. So with the openness and transparency of the judicial activities, including the judgments and everything in the court, everything in the procedures, the witness, the evidence, the procedures, the reasoning of the court, all such kind of things are brought into the sun, on the sunshine. And sunshine, it is says, based preservatives. Yes. And it is said that justice should not only be done, but should be seen to be done. So it is a way that everything displayed in the sunshine. You can look every factors and every details of the case, and so in this way, some departments or some say government departments or some other units, they just keep them away because
one of the popular proverbs that went viral on the internet since Mr. Xi Jinping took office was to put power back into the cage. Perhaps the release of such judgments and verdicts on the internet would be a serious attempt at house cleaning. You are watching Dialogue with Judge Zhang and Anna Tangen. We're discussing the latest release of or publication of judgments and verdicts on the internet to promote transparency, and also at the same time we try to protect privacy. How do we look at the relationship? We're going to discuss such issues when we come back. Please stay tuned. Welcome back. Judge Zhang, legal authorities in China have hesitated for a long time before moving forward in the correct direction about promoting transparency about the first trial. Why did you finally decide to also release publication about the first trial?
Yeah, actually, you see, there's a lot of complaints, a lot of shouts, a lot of opinions or bad opinions about what is going on. What is going on with Chinese court several years ago? So it's necessary for us to take actions and to push forward in this directions. Yeah.
What would usually happen on the first trial?
Yeah. You mean the first instance?
Yeah.
Yeah. First. Yeah. You see, the procedure systems in China, we have the so-called two-instance system, and for the first instance, it is the beginning of the case, and it is usually handled by the court in the local cities or local districts, and for the first instance, the main task of the judge is to ascertain the facts and apply the law correctly. But with this instance, still it is not final, and the parties can bring up appeal to the upper court for the second instance, and the second instance would be focused on the application of laws, and second instance would be final. And final for the valid for the enforcement.
Judge Zhang and I were discussing some of the uncertainties in the first incident, and in the case of the United States, I'm wondering what should be done to protect privacy of, for example, movie stars. Recently we had the divorce case of Wang Baoqiang, one of the movie celebrities. Actually, he had stolen the spotlight of the Rio Olympics with the dramatic announcement of his divorce overnight. So, what would be your measures to be taken to protect the privacy of the famous individuals?
Well, I don't think just because you're famous that you're, you should be treated differently from anybody else. I mean,
of course.
Whether it's you, me, somebody who's cleaning
Just
the streets,
people should be regarded as equals before law.
In terms of this, now obviously you can redact, that is, cross out sensitive information, dates of birth, locations of property, things like
just as anybody else.
Yes, and these are things people need to know. But if there are material allegations that the court is relying on, all right, facts, he slept with 16 women, or this happened, or that happened, and they're using these as the basis for their judgment, then these need to be in the record. Otherwise, it's not clear. And everyone will start to say, oh, what really happened? Oh, there's something going on here. So for judicial economy, to preserve faith in the system, you must have enough facts there to make it clear what the ruling was based on. And this is very important. China does nothing differently than they do in the West. The first instance is what we call the trial court, and as I said, a determination of what are the facts of this case. Then they apply the laws, and then we would call it an appeal court. They call it the second instance, and this is when you go and you say, look, we're given the facts, were the laws applied correctly to this series of facts? And you can only do that once you have the facts being known.
With the revised regulations, there will be many benefits. For people of different walks of life. For example, case study has always been an important practice for schools of law in different countries. We used to have case study that were tailored to look politically correct and more acceptable by teachers and students in the classroom. Today, the materials of the posted judgment documents will be the original and would be genuine or try to be so. Do you think this will make a sea difference for schools of law and students in particular to have a real picture and a complete picture so that objectivity of the case will not be compromised?
So actually, you see, the publication of such a huge amount of judgments and rulings are a great treat for those scholars and experts and those students. You see, this afternoon we also had a seminar and some scholars and from Renmin University, from some famous university. They just came and say, okay, it's really great, and we could see everything in original and what is really going on in your court. And through this, we not only can make a thorough study of your judiciary system, but at the same time, we can find out which laws. You see, now we have 251 laws exist valid nowadays, and through the study of these kind of judgments, they find out only more than 40 or 50 around laws are repeatedly or often used by the judges. So it is also a way for the improvement of legislation. So the study will be in all around way by these schools with the use of such kind of website.
And does it come as a surprise that with the promotion of the transparency, a number of lawsuits have dropped significantly?
No, that's the whole point. This is judicial economy at work. When you can go online and you can say, look, I'm going to look up the facts of your case and how they've been decided, how the law has been applied. And you go in there, you do a word search, and you find 10,000 cases that very close factually, and how they came out. And 90% came out a certain way. You can then go to your client and say, look, you're not going to be successful, or you're not going to be successful. we need to be very clear about this. Now, the other side is doing the same thing. So this is the way that you get the parties to come together. They can't, come up with wild stories about how they're going to win and how, everything is unknown, because they do know, and they know that the judge will be looking at the same cases, the same fact situations, and they'll probably come to the same situation, result.
So actually, you can expect that the outcome of the judgment if you go to court, and then they say, okay, it's too costly and too expensive to bring so many disputes to court. And as long as we have got outcome beforehand, so we just try to resolve these disputes between ourselves.
So one of the major benefits for clients would be a closer look, and they'll shape their anticipation and build a proper, reasonable expectation
exactly.
for the outcome of the lawsuit. Why did most lawyers show dissatisfaction with the release of such publication? Because they say this revised regulation about judgment documents and verdicts will cost them more time, and that will seriously increase their burden.
You mean
the lawyers throughout the country are obviously unhappy about the increase of their burden.
I mean, in the U.S., we have the same thing. The court will sometimes tell the lawyers, I want you to write up the facts of the case and the conclusions of law and submit them to me, and then I'll revise them or I'll change them or whatever. So they might see that as a burden, but the fact is the number of lawsuits is going down, right? I think people are more certain about what the outcomes are going to be. So from an overall institutional basis, it's far better. In terms of individual lawyers, yes, sometimes they're a little bit concerned about the unknown, but this is not doing it. It's quite the opposite. It's giving them the ability to advise and counsel their clients, which is what their first priority is, not to try cases, but to counsel, to give good advice to their clients. And this is the most important thing, and sometimes overlooked when you see all these television dramas with everyone banging away and civil courts and lots of colorful testimony.
So actually, as far as I know, most of the lawyers are happy with the publication of the rulings or judgments, and whether or not they go through or retreat or get access to the website is up to them, and I don't think it's a burden for them.
Well, of course,
I'll tell you a funny story. When I was a young lawyer, an old lawyer told me, he said, listen, the worst thing you can have in a case is a lot of facts, because it prevents you from just making up a really good story. So to the excess certainty in there, it then increases the ability of the individual lawyer to try to be very persuasive. When you have more facts, there's less ability to do that. So from that, they might be looking at that situation.
Yeah.
Do you foresee any major challenges, more challenges to have?
Sure, of course. You see, there's some people or some experts have raised up such questions about similar cases are treated in different ways. And with such kind of publication of judges, it is easier to find out these cases. And then we'll try to deal with such situations, of course.
Thank you very much. And thank you for watching. I'll see you next time. Goodbye.